Where is Mr. Dolan?
Good afternoon, Your Honor. William Dolan, standby counsel for Mr. Brian Elkarak, who is present on the Zoom.
Good afternoon, Mr. Dolan. Good afternoon, Mr. Elkarak. So the matter is on today for hearing on was Mr. Abdullah Bey's motion for reconsideration that the other two co-defendants moved to join. And while I'm not sure that it was the motions to join were ever officially allowed, if they haven't been, I hereby allow them orally, and I think I did so last time in any event. I intend to hear from each of the defendants who wishes to present first, then obviously from the Commonwealth. I note that this is a motion, style is a motion for reconsideration of two rulings. One is Judge Judge Boudreau's motion to ruling on the motion to suppress, and then Judge Hagan's ruling on the motion to dismiss. Judge Boudreau addressed, we split them off because I indicated that I would not reconsider the motion to suppress that Judge Boudreau heard. He has issued a decision on that. But I indicated that I was prepared to treat the motion to reconsider as a renewed motion to dismiss because there was a change, an intervening change in legal authority, such that I was prepared to treat it as a new motion to dismiss or a renewed motion to dismiss. And so that's what today's hearing is on. We also have to, at the end of today's hearing, discuss scheduling issues, which I'll explain. There have been some developments on that front as well. But Mr. Abdullah Bey, since it's your motion that got this underway and the other two co-defendants have joined, I'll hear from you first. I would urge you to focus on what's new here. I say that because we don't have unlimited time. So to the extent that you've already made arguments and they've been ruled on by Judge Hagan, I urge you to not to spend a lot of time on those, but rather to spend the time on those arguments that haven't been made, that are why I'm willing to treat this as a renewed motion to dismiss. You have the floor, sir.
I'm muted.
I think maybe Mr. Nangas, he can't unmute himself either. It seems to be that you either need to change the settings or individually unmute people. Yeah.
Okay, I'm unmuted now. Regarding Judge Boudreau's ruling, it was only 2 pages, and he didn't really make a finding on any of the arguments that was presented from myself or from the Commonwealth. So it's very difficult to argue anything new because I'm not sure what he based his decision on.
Today's hearing, I'm not addressing that ruling. Judge Boudreau has reconsidered or addressed a motion to reconsider and denied it. I don't think procedurally that's before me. That's what I was trying to get at.
Oh, I may have misspoke. I was speaking about Justice Hagan's decision on on the motion on the Bruen motion that I filed. I filed a 60-page motion. His denial was 2 pages, and he didn't address anything that I stated. In the prosecutor's opposition, they reference longstanding prohibitions which have nothing to do with my argument against the unconstitutionality of Massachusetts licensing scheme. The Supreme Court in Bruen specified, and I'll read it directly. I do have a 6-page presentation, but since you said to keep it brief, I'll try to keep it brief because most of this is already filed in the original motion. But the Supreme Court clearly specified, in keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulation, Only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Bruen directs judges to perform a text, history, and tradition-only analysis to the Second Amendment without any judicial balancing of the government's interest in the challenged law against the importance of the asserted right to keep and bear arms. I have provided copious amounts of case law showing the historically analogous laws that are similar to the Massachusetts licensing scheme, all of which are slave laws. I'm not a slave, I'm not Negro, I'm not black, I'm a free man, and all free men have the unlicensed right to keep and bear arms. In the prosecutor's opposition, he mentioned that there's 43 states that have licensing schemes. I believe it's over 27 states of the United States have constitutional carry or permitless carry laws. So his alleged statement of statistics is inaccurate. And secondly, in my original motion, I specified that since Bruen, at the time of my arrest, that statute was unconstitutional because Bruen had declared it unconstitutional. And as you know, as a judge, all laws which are declared unconstitutional are void ab initio, which means during the time of my arrest, since prosecutors were not severing the unconstitutional provisions that they deem unconstitutional at that time, to apply it to me now retroactively is ex post facto law, which is again unconstitutional. I have provided case law after case law showing how the only historically analogous laws that the Commonwealth are trying to enforce against me are slave laws. I have an example right here from Virginia. No free Negro or mulatto shall be suffered to keep or carry any firelock of any kind, any military weapon, or any power or lead without first obtaining a license from the court of the county or corporation in which he resides. And Virginia isn't the only... Yes.
Mr. Abdullah, I guarantee you, I promise, that my ruling will not in any way, shape, or form be based on any laws that were either sort of core slave laws or peripheral slave laws. I promise. That would be unconstitutional in the extreme in light of several amendments to the United States Constitution. My question is this. And I think you make a persuasive point that the Supreme Court of the United States has, if not held, and at least indicated that to justify firearms regulations, they have to be based on traditional sort of regulations of a type that were known in effect to the founders of this country. My question is, I don't know that I have from either side any information about what rules or laws existed in Massachusetts at the time the United States was founded regarding who could and could not own guns or how they were regulated. So I guess what I'm asking you is, if I accept your premise, and I think it's based on a fair reading of Bruen, but if I accept your premise that what the Supreme Court tells me I have to do is look at what sort of gun regulations were in effect at the time of the founding of the country, I'm not going to look at slavery laws or laws based on racial discrimination because they've all been invalidated constitutionally, so I can't do that. It would be wrong. My question is, and it's a question also for Mr. Vanepps, what, if anything, was the law in Massachusetts at the time this country was founded with respect to gun regulations?
I believe I can answer that question because it exists in the historical analysis that took place in the Heller Court. It exists in the historical analysis that took place in the Bruen Court, as well as the Young versus Hawaii case that happened in, I believe, the Ninth Circuit that the Bruen Court referenced as well, that there were no licensing laws that applied to quote-unquote free white persons. There were no licensing requirements whatsoever. In the historical analysis, they may have shown regulations such as sensitive places or regulations that deal with the concealed carrying of firearms, but nothing regulating the open the licensing of the open carry of firearms, which I'm essentially being charged with exercising my Second Amendment right. I'm not being charged with anything else. I'm being charged with bearing arms and being part of a militia. That's what I'm being charged with. There were no historical laws that prevented free people from exercising the right to keep and bear arms without a license. It does not exist. It only exists in slave laws. And that's why I keep bringing it to the court's attention, because the prosecutor has the obligation to show that there were laws that licensed the free citizens of any state, which required them to keep and bear arms, and it doesn't exist.
Well, I mean, unfortunately, I'm quite sure Mr. Vanepps won't try to justify the Commonwealth's gun licensing regulations on laws that enforce slavery. I'm sure he won't, and if he did, which he won't, I would reject them immediately. I guess the question is, both Heller and Bruen contain disclaimers, if you will, that they don't purport to strike down individual states' reasonable prohibitions on gun, or I shouldn't say prohibitions, but regulations of guns. So I guess the question is it your position that if I reread Heller, Bruen, and the Hawaii versus Young case, that I will find in those cases legal holdings, if you will, that in Massachusetts there were no restrictions on, as you put it, free white men, understanding that the racial distinction is now totally irrelevant, but be that as it may, that's, as you're pointing out, that's the state of affairs in 1776. Is it your position that I can find that in those three cases that Massachusetts had no sort of gun regulation that's analogous to its current licensure provisions?
I believe that I am asserting that if you look into any of those cases, as well as the historical analysis that the Commonwealth must provide according to the standards set in Bruen, you will not find in any state where there were laws on the books which required a free individual to have a license to keep and bear arms publicly. It does not exist. The only time it exists is in slave laws, and then around the 19th century, after the coup in 1861 and the overthrow of the Democratic Party, then you start to see the enforcement of licensing once they got away with the the concealed carry of firearms. But I've stated many times, even in the Bruen court and the Young versus White court, where several of the Supreme Courts of the several states dealt with state versus none, I believe, or noon, where they specified that it's no crime to openly carry a firearm. It only exists in the malicious intent of doing so. And I'm only being charged with the possession of a firearm in public without permission from the state, because a license is permission. And again, you will only see that slaves and white abolitionists, because the Democratic Party was trying to, they were murdering Republicans and white abolitionists and free Negroes. They only required slaves, free Negroes, and white abolitionists to get permission from the state to keep and bear arms in the promotion of slavery. So you have to consider the entire historical analysis with its proper context in viewing any type of licensing scheme whatsoever, because it is a fact that the Second Amendment is a pre-existing right. It is a natural human right, and no institution can can license a natural human right. It only applied, they only did that to slaves.
Mr. Abdullah, I'm not terribly persuaded by the natural rights theory.
That's in the Heller court. That's in the Heller court, that the Second Amendment is a pre-existing natural right.
My concern is what the Constitution provides, not what some theory of natural rights provides.
The Heller court argued.
One person's right, but one person's natural right is another person's. I can only enforce laws that I can read.
Yes, and the Heller court specified that keeping and bearing arms was a pre-existing natural human right. Since, and I believe you're about to go on the course that most thinking was back then, that natural human rights are different from others, which is why they were licensing slaves, because they had that same opinion that, well, these blacks don't have the natural human right to keep and bear arms and protect themselves, but whites do. That was the entire reasoning behind it. It is a natural, God-given right, and I provided some of the case law that prove that. It's not my personal opinion. These are things that have been litigated in the Supreme Court and many other courts, and it's blatantly obvious that when the courts of Massachusetts in Chief of Police versus Shelburne versus Paul Mayer, this is from the Massachusetts Courts of Appeals, they specified that since the Second Amendment is not an individual right, it is not unconstitutional to license it. Now, we all know, post-Heller, post-2008, that the Heller Court decided that it has always been an individual right. So by Massachusetts' own reasoning, which the Court of Appeals is above the Superior Court, by your own reasoning, to license a right which is free and open to all is unconstitutional. This was specified in the Murdoch Court, which is the Supreme Court. This is historically evident. Most honest researchers that talk about the licensing schemes of any state show the historical analysis of how licenses in every state only apply to slaves. It doesn't matter if it's the Commonwealth of Massachusetts. It doesn't matter if it's a southern state, a western state, a northern state, a middle state. It only applied to slaves. That is the only historical analogous case that you will find in history that Bruen requires you to make your decision on that exists. There is no regular, the entire citizenry of this state needs to get permission from the state to keep and bear arms. It doesn't exist outside of slavery.
I've got the argument. Let me ask you, because I am constrained on time, is there any additional area of argument that you wish to make? I'm going to then turn to the co-defendants to see if they want to amplify or extend on your argument, but I don't want to cut you off if there's additional arguments you wish to make.
Yes, and thank you for your consideration. But in the Guardado case, the judge specified that there was some type of due process right under the Second Amendment. I wasn't aware of any due process clause in the Second Amendment, but I would like to argue that the police, the prosecutor, etc., have no probable cause to even facilitate an arrest because clearly I have due process laws under the Second Amendment, and I'm only being charged for exercising my Second Amendment right. And in the Guardado case, it specified that. So I'd like to, in the original motion, I called it, I forgot exactly what I called it, but it was faulting the indictment. I like to fault the indictment on that premise because I'm just being charged with exercising the Second Amendment, and if I have due process rights under that, and of course, with the several copious amounts of case law that I provided from the Commonwealth of Massachusetts, that knowledge of a firearm or possession of a firearm alone does not give rise to a reasonable suspicion under the Fourth Amendment, then this entire thing must be thrown out and dismissed immediately because I've committed no crime amendable to the Constitution. I have violated no constitutional laws. The statute was already declared void and ab initio during my arrest. So again, to continue to charge me with this is unconstitutional. There's no historically analogous laws that required any citizen from any other state who acquired their arms legally, which I passed a state and federal background check, in a state that doesn't require the license to open carry any firearms, was traveling to another state that doesn't require the license to open carry firearms. There's no laws that regulate that historically whatsoever. So I was also challenging that as well because Massachusetts does have statutes that requires non-residents to obtain licenses. There's no historical regulation in existence that has ever done that. So I'm only being charged with unconstitutional laws. And again, to continue to charge me with these laws post severance is ex post facto. It doesn't get any clearer than that. So not only is it ex post are these ex post facto laws that I'm being charged with in retrospect, because at the time of my arrest they were unconstitutional based on Bruen, but there's no there are no other laws in existence during the founding time of the Constitution that required anyone to obtain a license. And right now, the majority of states have constitutional carry laws where they don't need licenses to keep and bear arms so long as they pass a background check and they're of age, which those things are long-standing regulations. Those things are reasonable. Those things do make sense. It does make sense to ensure that the individual who's acquiring an arm is not a felon, but simply But now, just because I'm being charged with carrying an arm, if I get found guilty, I would become a felon. So
was that sort of restriction that convicted felons were prohibited from owning firearms? Was that known to the founders in Massachusetts?
No, but
So
there was a minimum age requirement.
Wouldn't your argument then mean that even if it makes sense not to allow felons to have firearms?
I'm not challenging background checks. I'm not challenging the prohibition of felons. And in fact, it would make sense that a felon would need a license. That would make sense.
But the standard isn't whether, as you're saying, it is not whether the regulation makes sense. It's whether it was known at the time of the founding. So it seems to me that your argument, if I adopt it, might also strike down the prohibition on felons possessing firearms or minors possessing firearms. If this test is what was known to the founders, if it wasn't known to the founders, it can't be enforced. That's not
what Bruen says, and that's not what I'm saying. I'm trying to abide by what the Supreme Court said in Bruen. I'm not trying to make anything up. I'm not trying to create my own opinion. That's not what I'm doing at all.
I know. I'm trying to understand if in fact Bruen holds that I have to invalidate any gun regulation that wasn't some form of which wasn't known to the founders, then even though you're not challenging them, the result of that would be that if the founders didn't prohibit felons from owning firearms, we can. And if the founders didn't prevent minors from owning firearms, we can.
That's not what Bruen states. Bruen says only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So based on how the law works, if I commit a crime and I get incarcerated, then I lose certain rights. So
let me turn to Mr. L. for Libertad. He raised his hand, and I do want to make sure everybody has a chance to be heard in the time that we have available. So, Mr. L. por Libertad, what is it that you wish to say?
Oh, I joined.
I can barely hear you, sir. I think something's wrong with your mic.
Can you hear me now?
Not very well. You sound like you may want to check your settings to make sure you're using the right mic setting. If you click on the little arrow next to the mute button, there's an up arrow. If you click on that, it'll open up a menu, and you may want to try to change your microphone setting.
Can you hear me now?
No, I mean, just barely. I can't follow an argument at that volume.
Well, while he's trying to fix his mic, in my reading of Heller, Bruen...
Hang on, Mr. Abdul-Bey, before you do that, I want to give Mr. El Karak a chance to speak as well, if he wishes to.
Okay, I was just trying to answer your question.
I will give you a chance after they speak. I'll come back to you.
Okay.
For final words.
Can anybody hear me now?
Just something is working in your mic. You don't have a mic set. All right. Well, lean as close to the computer as you can and speak really loudly because.
Okay. Can you hear me now?
Just go ahead.
Okay. So, I comprehend what you were trying to say about would that go for if a felon was told that they cannot carry? This is the problem that we've had from the beginning, because we're destroying the bedrock principle that our rights are given to us by none other than God. You see, the reason that we're in this whole predicament is that men want to control men and decide who can and who cannot do as they please as an individual. This is the whole reason to why we're in this predicament now. And it hurts me to see the wordplay trying to be used against my brother to sort of try to catch him in a trap when he's basically standing and asserting his right as a man, a right that's not given to him by another man, but a right that's given to us again by God, no matter what it is that you call God. Because at the end of the day, if it were that rights were given to us by other men, as it seems to be what's going on today and age, then there would be no freedom at all. And the problem is that the state of Massachusetts, from the beginning, has been looking for loopholes, and not only the state of Massachusetts, but most states in the union that don't agree with people that look like me and my brothers, my peers, having their rights. They've tried to basically go above God, and it's sad that we have to keep coming up with all these arguments and showing all the proof that men that don't look like us have at one point or another come to the comprehension or understanding that it just doesn't make sense and it's just not fair. And it just is blatant at this point. The Constitution is clear as day, and the Constitution again didn't give anyone rights, but just assert the rights of men. And it's just it makes no sense that still today in 2023 we're going through this, right? And then to act as if we're trying to make progress. There is obviously no progress being made. These rights were agreed upon by the European forefathers who came here, leaving Europe because of taxation without representation. You know, these rights were agreed upon, you know, by men that don't look like me.
Mr. Libertad, I don't want to cut you off, but the argument that you're making here is a philosophical.
I'm just trying to come up with an understanding. It's not about being philosophical, because if we were making arguments based upon the law, we would not be in this predicament in the first place. The law is clear. The Massachusetts Constitution says that we have the right to keep and bear arms, and that right shall not be infringed. The federal Constitution, which is the supreme law of the land, says that we have the right to keep and bear arms, and that right shall not be infringed. Okay. The Supreme Court in Heller, Supreme Court in McDonald, the Supreme Court in Bruen have all stated clearly that the Constitution shall be interpreted as written, and it seems that as in every state, judges can choose to interpret it as they please. The Constitution doesn't say that you have the right to keep and bear arms only if you have on a black T-shirt. The Constitution doesn't say you have the right to keep and bear arms only if you're so-called white or you're so-called green. It says that that right is open to all. The Constitution doesn't say that
I understand.
The Second Amendment is a second-class citizen.
I understand your argument. I'm going to have to stop you. The argument here is a very specific one. I allowed Mr. Abdullah Bey to expound on it at some length because his argument was specifically directed to the issues raised in the motion to reconsider.
The
arguments you are making both repeat what's in several of your pleadings and also are not specifically focused on the legal issue at hand. I appreciate the passion that you bring to your argument. I respect it, but I only have a limited amount of time, and I need people to focus on the issue, the specific issue that's raised in the motion to reconsider. I don't, unfortunately, have time for a sort of a sweeping review of the source of sort of legal rights, whether they're granted by men or granted by God, is a fascinating discussion, but won't help me resolve the issue that's before me. So I'm going to turn to Mr. El Parak to see if he has anything he wishes to add.
He's muted.
We need to unmute Mr. El Parak.
Good morning, everyone in Bonnell. Excuse me, good afternoon, Will. So I don't really have anything to say. I will just like Jamal to finish what he was saying. Everything he's saying is knocking everything right on the head, and same with Lucha. So I stand behind him, and I yield the floor. Thank you.
Thank you, Mr. El Parak. Mr. Abdullah Bey, I had promised you that I'd come back to you for a final word before Mr. Vanepps or Mr. Rawl addresses the Commonwealth's position. So We really don't have a great deal of time, but I do want to hear if there's loose ends that you feel need to be tied up before the Commonwealth argues.
Yes, thank you. I believe your question was if the laws weren't known to the founders at the time, then we essentially cannot enforce them. I'll first read Bruen again. Quote, only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. A similar question was asked during the Heller Court when the prosecutors with malicious intent were arguing that the Second Amendment only applies to muskets and things like that. And the question was, well, could the founders have known about automatic rifles or machine guns? And that question was already answered in the Heller Court. So to answer your question, I would ask you to revise the Supreme Court's decision in Heller, because it was already decided that although the founding fathers did not know about the Armalite style rifles and M1A1s and AT4s and grenade launchers and tanks and stuff like that, although they didn't know about these things, some of these things are in fact arms protected within the meaning of arms in the Second Amendment. So I would ask you to revise or review that, as well as review the prosecutor's argument in favor of these statutes, because they have none. You have to make a decision based on what I present and what the prosecutor presents. And the prosecutor has not provided not one law from the Commonwealth of Massachusetts or any other state that historically is analogous to either the statutes I'm being charged with right now, or the other statutes that I challenge regarding non-citizens requiring to have a license from another state of arms that they legally, lawfully have purchased. They have provided not one law that supports their claim that these laws are in fact not unconstitutional. And again, and this will be my last statement, I'll read for you again. This is Chief of Police of Shelburne versus Paul S. Mayer, 1-6 Mass, Appellate Court 543. The court clearly specified that since there is no individual right to keep and bear arms, to license the keeping and bearing of arms is not unconstitutional. So now I assert, since post-Heller, the Massachusetts courts has to agree that since the Second Amendment is an individual right and has always been an individual right as confirmed by the United States Supreme Court, then that means to license it is unconstitutional. And the historical analysis of that shows that to be true. And in one of the cases that I was going to provide today, it clearly showed that there were laws on the books that regulated Negroes and did not apply to whites at all, and if challenged, would have been declared unconstitutional. And this was an amicus curiae brief to the United States Supreme Court in favor of I believe it was the Firearms Policy Coalition, but in favor of the individual arguing that the that the New York statute was unconstitutional, which we already know the United States Supreme Court agreed.
Thank you, Mr. Abdullah-Bey. Mr. Vanepps, I'll turn to you. Again, I am under time constraints. As I read the defendant's submission, I also read the Commonwealth's opposition. And I think I understand all the arguments in it. You feel free to reiterate whichever ones you think are most important for me to focus on in light of Mr. Abdullah-Bey's presentation. But I would ask you to be sure to address his argument. Specifically, I want to know your position as to why you believe he's wrong that Heller and Bruen, especially Bruen, seem to require judges to look back in evaluating whether firearms regulations violate the Second Amendment's protections, seem to require that judges look back and analyze whether the regulations at issue were at least analogous to regulations that were familiar to the founders. Obviously, if you don't agree with that position, I want you to explain to me why you think that's not a correct statement of the law.
Your Honor, I'm going to turn it over to ADA Rawl
That's
for
fine.
the argument, but I will add, Bruen did not, in its holding or in any way, purport to undo licensing regimes across the country. And in particular, we know that because in the concurrence by Justice Kavanaugh, with whom Chief Justice Roberts joined, the first thing they do is talk about the limits of the holding in Bruen, which says, quote, first, the court's decision does not prohibit states from imposing licensing requirements for carrying a handgun for self-defense. In particular, the court's decision does not affect the licensing regimes known as shall issue regimes that are employed in 43 states. That's at 142 Supreme Court Reporter at page 2161. And before I turn it over to ADA Raw, what I will add is...
And your argument is that the minority in Bruen surely would agree with that part of the concurrence.
Well, yes.
That there's a majority position on the court for the proposition that it doesn't purport to strike down shall issue licensing scheme.
Yes, and the argument, Bruen did not purport to undo licensing. Bruen invalidated a portion of the New York licensing scheme that, despite having all these perfectly acceptable requirements, had a requirement that also vested an unlawful amount of discretion in the licensing official, which was not supported by the Second Amendment. So it is not the case that the holding of Bruen is as expansive as what the defendants have argued. I'll just turn it over to ADA Rawl because I don't want to steal the win from his sails.
So, thank you, Your Honor. I want to start by saying first that I think that Bruen, another way of looking at what ADA Vanepps said is that Bruen seems to be suggesting that licensing schemes, if they are shall issue and are based on objective criteria, are not sufficiently burdensome and are presumptively lawful under the Second Amendment. I mean, that's not just in the concurrence. In a long footnote in Justice Thomas's decision, he specifically says that, we are not suggesting in any way that all these other states and their licensing schemes can't continue to operate, which would include criminalizing. And I just want to say that insofar as this a motion for reconsideration, all of these arguments were raised about severability and the effect of Bruen in front of Justice Hagan. The fact that his opinion doesn't detail every explanation from his perspective doesn't mean it wasn't considered. But that being said, I think the question first is whether the simple task of getting a license under Bruen, under McDonald, under Heller, really does constitute a sufficient burden under the Second Amendment, or is a presumptively lawful regulation. And there's a tension here because that part has been addressed in numerous other decisions in the circuits, which have splits about felon in possession of a firearm statute. There's the Rahimi case out of the, I want to say it's the Fifth Circuit involving domestic violence orders, but all of those have to do with either complete prohibitions of someone obtaining a firearm, or as in the example of Bruen, a de facto ban because of the way it was being exercised in New York City. So we're talking about a complete ban on the right to bear arms. Now, the court did ask about historical analogs, and I did put in my brief, my supplemental memoranda, a footnote that details at least two cases. There are some additional cases the court can look to, but there's been, even though the court has consistently said one does not need to be required because there has always been longstanding prohibitions of the mentally ill and the dangerous having firearms, that Nutter case and the Jimenez-Shiloh case, but also even in the recent decisions in Rahimi and Range versus United States, which is, at least one of those is going to the Supreme Court soon, detail that there is a substantial historical analog for disarming people, not just based on statuses that we would consider improper and abhorrent today, but statuses based on concerns about public safety. So, for example, Massachusetts, Pennsylvania, and numerous other states had statutes that not only allowed them to disarm people they were concerned about creating terror in the community, but they also prevented people who didn't pledge allegiance to the state from carrying firearms. Pennsylvania in particular completely disarmed whole categories of people who would not swear allegiance. That's contained in some of those numerous decisions that I cited, but also within Bruen itself, there is some discussion of some of this, and even in the immediate aftermath of the revolution, there is precedent in Massachusetts and other states to completely disarm people who wouldn't swear allegiance to the new United States and remain allied with British loyalists. And so there is a history of completely disarming. That's not what the regulatory scheme here is doing, but there is a historical analog for completely disarming people that the state.
And is this argument in your opposition to the motion for reconsideration?
No.
It is referenced in the two. So what I did is I cited the two cases that talk about this more extensively. I didn't know what degree, because I also believe, just as a matter of law, that what Bruen and the other Second Amendment cases saying is that these regulatory schemes, at least in part, are presumptively lawful, don't sufficiently burden.
Where are the two cases you cite?
It's footnote 4. And Bruen itself also talks, and I'll talk a little about that, but surety laws and some of those others also allow the state to either temporarily or forfeit people's firearms.
Okay, I've got it.
So historically speaking, there is a precedent for it. And it's not just based on improper statuses, it's based on people's refusal to swear allegiance to the state, which suggests a few things, that it is in fact considered acceptable in certain circumstances to preclude people who swear allegiance to the state, for example, from having firearms because of concerns about public safety and compelling interests within the state. I think that's just one example, but surety laws that existed in Massachusetts to disarm and forfeit firearms involving people. There's actually a slew of statutes that make it as minor infractions as hunting in prohibited areas. You could be completely disarmed.
Slave laws.
Weapon could be forfeited. I didn't cite that statute because it just doesn't seem analogous to the scenario I'm arguing, which is about objective criteria for prohibitions of the dangerous and mentally ill. Because my overarching point is if some aspect of the licensing statute, which it seems that at least Mr. Abdullah Bey is agreeing, like background checks are considered reasonable. The question is whether the state can use a licensing process to require that. I mean, that's really just what the mechanism of the licensing process is.
Okay, so I've got the argument on that. I want to, because I'm short on time, I want to make sure that if there are any other arguments you want to underscore, that you have time to do it before I have to move on to the scheduling aspect of this.
Sure. The only additional things I will say is the court, even though I disagree with some of the decisions, the Rahimi case, and there is a dissent in the Range opinion that also provides more historical analogs that are relevant to this analysis, just in regards to public safety. And I would say it's a historical analog, not a twin. So the fact that licensing schemes didn't exist as the mechanism does not mean that the state wasn't able to regulate based on these legitimate concerns. So the final thing I'll say is it's phrased as renewed, but it's a brand new argument. I think I addressed it, so I'm not going to harp on it, but I would just rest on my memorandum about why this licensing scheme isn't an unconstitutional tax, and even if it were, the defendant wouldn't benefit from that. This just as we argued in front of Justice Hagan, this all has to do with the end goal being that they have to show the entire statute is facially unconstitutional, all aspects of it, in order to get around the fact that they failed to comply with the licensing scheme. That's clear under constitutional law and the severability doctrine, and based on the legislature's clear intent that it wanted all aspects of the licensing scheme to be in place. So if some were removed because of constitutional issues, their interest in maintaining it is still there. So I'll just end on that. I don't want to belabor the point.
All right, I understand the arguments, and I'll take this matter under advisement. I will try to get a decision out as quickly as I can, but it's the arguments on both sides warrant some careful consideration, so I don't want to rush it. And that leads me to the scheduling issue that I need to raise with counsel. When I say counsel, obviously pro se counsel as well as legal counsel. These cases currently, I think, are scheduled for trial on August 9th. My memory is that there are 2 other co-defendants whose trials are scheduled for August 7th, and there have been some discussion of consolidating all of them, or at least some of them. Since that time, a murder case has been assigned to this session to start July 31st, which regrettably takes precedence both because of the seriousness of the offense and, more to the point, because the defendant is in custody awaiting trial, which gives it priority. Obviously, and I am told, although I'll have a clearer picture of this after our next hearing, which is right after this hearing, I have a hearing in that case, but I'm told the parties expect that case to go forward and to take roughly 2 weeks, give or take. So that means we're going to have to rethink our trial schedule, because obviously we can't try this case on August 9th with a murder trial starting on the 31st. So my question, and I'm open to suggestions from both sides as to how to handle this. The session could accommodate a continuance roughly of 1 month to start this case on September 10, 11, 12, somewhere in there. I mean, the 10th may not be ideal, but say September 11th. Okay, I'm going to ask everyone who's not addressing the court, especially an individual labeled Rashad's iPhone. Thank you, sir. I don't know anything about the Commonwealth schedule. I don't know anything about the defendant's schedule as to whether that's even a possibility. But it does appear to me that at least a short continuance is going to be required because of the session schedule. But I'm open to suggestions from anyone who wants to make them as far as what works. I'm particularly, I suppose, want to start with the Commonwealth because you have a number of co-defendants whose cases you have to juggle, not to mention other cases as well. But I also want to hear from both defendants, pro se defendants, and standby counsel as well. Mr. Vanepps?
Your Honor, I'm basically booked week to week, and in some cases double booked. If the court is looking to continue this, I could probably try this. And I think it would be. Sorry, I'm just looking at my calendar, Judge. I mean, I don't think I could do it in September without booking it for something. I already have a trial with Ms. Raisla Cohen for the week of the 18th of September. I know one of the co-defendants is going to be on trial in New York starting on the 28th of August. So my schedule, I think, the soonest I could do it, if it's continued, would probably be November 6th.
Okay, let me ask the pro se defendants and their standby counsel whether November 6th works for everyone.
Your Honor, speaking for Mr. Abdullah Bey, so I was, force muted. Mr. Abdullah Bey did say in the text on the meeting chat during the Commonwealth's argument, I would like to briefly respond to what Attorney Vanepps stated.
I'm sorry, with respect to the schedule, there's a possibility we could do some of the co-defendants alongside co-defendant Quinn Cumberlander, who is scheduled for the 21st of August. That's also a possibility, but
the session couldn't start on the 21st of August. That's the problem.
Okay, all right. I just wanted to throw it out there. Sorry.
Mr. Thompson, sorry, Mr. Thompson had the floor.
So just because the meeting chats are not part of the record, I wanted to put it on the record for Mr. Abdullah Bey. He stated, I would like to briefly respond to what Attorney Vanepps stated. Once the Commonwealth is done, not once has the prosecution mentioned licensing of arms, and then he also said separately, those are slave laws. I just wanted to put that on there, with your honor having taken it under advisement.
Thank you, Mr. Thompson and Mr. Abdullah Bey. That Mr. Thompson has read your chat, so I understand the argument. We're moving on obviously to scheduling because I have to.
For scheduling, I can make myself available for November or September.
Your Honor, this is Attorney Dolan, standby counsel for Mr. Corral. So, August,
I know.
I was likely going to ask for continuance anyways from the August date. In terms of September, I have two other trials that are in Woburn for the 11th. I theoretically could do that as long as I was given leeway from perhaps other justices of this same court. I think that this trial would probably take precedent. I could do a little later in September. In terms of November 6th, I have a trial in New Hampshire that is one of those cases that is very old. It's been continued several times. It is one of those that it just cannot be moved. It would cause a great problem for my practice. So November 6th would not work. I could do perhaps a little later in November, maybe the 27th. And at that point, I'm probably closer to December 18th.
Mr. Reisler-Cohn?
I could do really any time in November or December. I do have the September trial the week of September 18th, as ADA Vanepps mentioned. August is flexible for me, but I know that's not going to work for the session.
What kind of cases do you know on September 18th, Mr. Vanepps and Ms. Reisler-Cohn?
It's a 2021 two-defendant trafficking case. The co-counsel is Attorney Sheketoff. Both defendants or one defendant's on the street, the other defendant is serving a sentence.
Okay, so nobody's held a waiting trial in this case.
That is correct.
All right. So, and then I can't remember what Mr. Dolan and Mr. Thompson said about September 18th. Mr. Dolan, I know you have a trial. Well, I can't remember what you said. Actually, you said you have a trial for 11th.
So November 6th would be the one that I could not do November 6th. In terms of September, I could do really any week in September. I will say between the 11th and the 15th, I have two trials set for other cases in Woburn.
If we set this case down for September 18th for trial, making the assumption, Mr. Vanepps and Ms. Reisler-Cohn, that together, and I say that the two of you together, plus any assistance you might need from me in moving the two co-defendant trafficking trial, could we try this case on September 18th? That's about the last day that I could start this trial in this session. It's actually really past the last day I could start this trial, but I think I'm pretty confident that I could get approval if this case goes into the next sitting in October to stay with it. So let me ask people, is the only impediment that anyone's aware of, and I'm addressing this to Mr. Abdullah Bey, as well as Mr. El Libertad and Mr. El Karak, is with the exception of the case that Ms. Reisler-Cohn and Mr. Vanepps have together on the 18th, is there any other impediments to starting this trial on September 18th?
I'm expecting my son to be born in November, so I would prefer sometime in December. I believe one of the standby counsels requested a date in December. That would work for me.
What's wrong with September 18th?
Well, September 18th, my rights have been violated since July 3rd, 2021, and I would expect them to continue to be violated, so I would not want to be potentially incarcerated when my first son is born. I'd like to at least be there when he's born. I was in jail because of these charges when my grandmother died. So I would like to, and they wouldn't let me go because I was in Massachusetts. My grandmother died. I wasn't able to see her. So I would at least like to see my son born.
Mr. Abdullah Bey, I could imagine, I obviously want to hear from the Commonwealth on this first, but I could certainly imagine recognizing that as a legitimate reason to want to schedule a trial at a different time. But to do that, I think, it would be somewhat extraordinary for me to delay a trial in the anticipation of your incarceration, which I have no opinion about because I don't know how the trial is going to come out, but I understand your concern about that it might come out against you. We could, I mean, I don't want to schedule this trial between Thanksgiving and Christmas. It'll be nearly impossible to impanel a jury at that point. It'll take forever. So I think if you wanted to go past your son's due date in Abdullah Bay, it would necessitate going into January. And the only way that I would be willing to do that is if all three defendants were willing to waive their rights under Rule 36, which grants a speedy trial. Because a continuance of that length is unusual given where the posture of the case is. On the other hand, given the reason that you are putting forward, I'm willing to consider it, but only if all three defendants are willing to waive Rule 36.
Well, if I may, I don't want it to just solely be because I'm expecting a son. There was I believe one of the standby counsels did mention that they could possibly do the date in December. So I'm not the first one to propose that.
But I would like to schedule this trial September 18th because it looks as if there's only one case we would need to push back. And it sounds, I'm hearing from counsel that neither counsel on that case objects to pushing that case back. I mean, we don't have attorney, is it Sheketoff? Is that who you said it was, Attorney Sheketoff?
Right.
Yes, Your Honor. Your Honor, and I mean, I will tell the court, obviously I haven't spoken to my client in that case. That case was supposed to go to trial in May. The co-defendant requested a continuance. We objected at that time to a continuance. So, if the court is going to schedule this matter for September 18th, and then we have to deal with scheduling, that is what it is. But I would expect that my client on the September 18th matter, would not want a continuance of that trial date. We did object the last time that trial was continued. I did want to say one other thing, which Attorney Vanepps had mentioned. One of the co-defendants has another trial coming up at the end of September. I'm not sure if that's Lucha El Por Libertad. He does have a federal matter in New York, and so I just wanted to inquire of him if he knows when that trial date is and if that's September 26th.
I have August 28th marked off as the beginning of that federal trial. I was going to suggest.
I wouldn't know because there's obviously something going on here, some sort of. I don't even know when I have trial, but it seems that Vanepps knows more than me. So it's obvious that the whole federal case has been made a part of this, which is not uncommon, when you're maliciously prosecuted against. But go ahead, I yield.
Can we advance the trial? Can we do it July 24th?
He knows more than me about my own trial.
I can't put that case in July 24th because then the murder, that effectively forces the continuation of the murder trial, which I can't do.
Judge, if the only time it works is September 18th, I will tell the court I'm going to have to move a bunch of cases, and I also, so the 18th, it shouldn't take that long. I'm going to be leaving town the second week of October, so I have like a definite hard stop date on my calendar of everything must be done by. I don't think this trial would go that long, but I don't know how long jury selection will take, and evidence should only take a couple days, frankly. So if the court needs me to move things, I will. But there's at least two trials I'm going to have to Actually, yeah, two felonies and an assault and battery that's an offshoot of homicide. I think.
Your Honor, one suggestion.
I could use a suggestion.
I wonder if it would be helpful, whether we can do it right now or not, but to have all of the defendants, and if they would like standby counsel to come with them in a breakout room to discuss whether they all would like to reschedule this for December or January in light of the fact that that would require them to waive Rule 36.
Why don't we do this? Why don't we set up a breakout room and send all pro se defendants and their standby counsel to the breakout room to have whatever conversation they want to have about that or anything else. We'll call the next case. I need to do that, but we can once you come back from the breakout room, we'll take a break from the hearing on the next case, see where things stand, and then we can go back to the next case after that. So
I think that my two other peers and I would rather be in the breakout room alone, with all due respect, and then we can speak to our standby counsel on our private time.
I'm fine with that too. Mr. Abdullah Bey, Mr. Elcor Libertad, are you both comfortable with a breakout room, just the three of you to start with?
Yeah, that's fine.
I think Mr. Elcor Libertad is still muted.
Yes, that's El Corral is muted.
Oh, I'm sorry. Where's Mr. Elcor Libertad? Oh no, I'm sorry, Mr. El Corral. I'm sorry. I apologize, Mr. Elcor Libertad. I just mixed up the names. Mr. El Corral is still muted.
He did send a message in the chat saying sure in response to Your Honor's question if the three of them wanted to be in a breakout room together.
Are you comfortable? You can send a message in the chat. I'm not sure where our host is.
Saying that he's
I agree with that. That's fine.
Okay, let's make a breakout room for the three pro se defendants. When you gentlemen are done in the breakout room, just come back into the main session. And standby counsel, if you can just stand by.
All right, I'm going to mute myself on
So good.
on this since I'm in the breakout room, so hold on.
Back in, okay? 1 second.
All right.
Yeah.
All right.
Well, I wasn't using the birth of my son as a bargaining chip. The judge asked me, I forgot exactly what he said, but he asked the prosecution and all the standby counsels what their schedule would be like. And then he asked me, so I brought up why I would prefer in December, like the other counsel suggested. All right, we're going back into the room, so hold on. I'm going to mute myself on here again.
want to talk about Rule 36, they've done so much already to shit on that rule. You get
Exactly. Yeah, hold on. This was muted because we're in a breakout room addressing scheduling. So I wanted to protect my co-defendant's privacy. But since we talked about it, now I'm unmuting the chat or the audio. Well, yeah, they did. He did try to coerce us to waive our rights. I caught on to that immediately. And because during, you know, for the Rule 36, they have to factor in who's responsible for the continuances of the case. And, you know, for some reason, they're not acknowledging how all of the standby counsels are booked. And the only way to have a hearing sooner is to move a bunch of cases around, which isn't feasible. Exactly. And even, I think it was Dolan, right? Whatever. No, what's her name? Was it Dolan? That he suggested a date in December, or was it?
Yeah, that was wrong. That was wrong.
Yeah. Yo, listen. You see how Vanepps knows when I'm going to trial on a federal case?
Yeah, and you don't. Yeah, that's crazy. That's crazy. The judge still didn't even make a decision on your recent argument, and he knows the trial date before you. That's crazy. And you didn't even get to appeal it yet, which would push the date back even further, but which doesn't even make sense. So obviously these people are colluding with each other and talking to each other and conspiring against us. But we already knew that from the beginning.
Yeah, but we have to make it clear on the record as well, so that they know.
Yeah, and this is what I wanted to address what Vanepps said before he passed it to, I forgot the guy's name, Ryland, whatever his name is. But
he said nothing.
I know, but what he's trying to imply that the Bruen decision stated that the licensing schemes in every other state is constitutional, and that's not what they said. They just made a distinction that they're not ruling on that. That's all they said. Because that issue wasn't even brought before them. You know what I'm saying?
When you speak on the dates right now, just also add all this that we're speaking about in, because you might be the last person they allow to speak. So just make sure you add all of this in that we just spoke about. The fact
he already said he's gonna take it under consideration, so I can't add anything as far as the Bruen thing. But that's why I kept reading Bruen, because, you know, they said that to justify its regulation, the government may not simply posit that the regulation promotes an important interest, which the guy that Vanepps passed it to kept saying public safety. That's their interest, which has nothing to do with which they can't use anymore. You know, they're going back to that same two-prong crap that Bruen already struck down. They're going back to the same exact reasoning, which doesn't make sense. You have to go by the historical analysis, period. They tried to use surety laws. The Young versus Hawaii court already addressed that, which Bruen referenced the Young versus Hawaii case, which I referenced the Young versus Hawaii case, July 3rd, 2021, handed the paperwork to, what's his name? Trooper Ryan Casey. You know, this is already out there that these surety laws have nothing to do with licensing schemes. It was if you were charged with possession of a firearm in public and like terrorizing people, then they would confiscate your firearm pending the charge, and you'd have to pay surety like a bond. That's it. It was just a bond saying that you're going to show up. And when you show up, you get your arm back if the case is dismissed. And then all those cases ruled that the mere possession of an arm in public is not a criminal act. He did not reference licensing laws at all. Not once. You know, but in these historical analysis that the Young versus Hawaii case did, they discussed all these things, how the general public could go about armed in public so long as they weren't terrorizing people, or like aiming it at people, or like, you know, acting in any other manner which would indicate criminal behavior. And they clearly specified that the mere possession of a firearm does not give rise to reasonable suspicion. So, which means the simply opening or simply being in public with the armed does not indicate criminal activity. You know, and all of those cases that court reviewed showing that people were arrested for bearing arms in public, those convictions were either reversed or the cases were just thrown out. That is the plain history of firearms regulations. And as far as like when he was talking about the what do you say, the long-standing prohibitions against like people that were in favor of the British, obviously you were just at war with them. That has nothing to do with the general population whatsoever. And even those people didn't have licenses. They were just unable to bear arms because they were on the side of their enemy.
Neither one of us were able to answer that, bro.
Exactly.
I reserve my right to speak on the record as well, and they just ignoring everything.
But that's why what's his name? Daniel Thompson noted that on the record that I wanted to object to Vanepps. But that's what I wanted to say. But whether I said it or not, the history shows, and it was addressed in Young versus Hawaii, that is not sufficient, nor I keep struggling with this word, analogous to any statutes that exist right now, at all. So they can't even use them.
When you answer the judge now, can't you just mention that? Say, listen, are you going to give me the chance to respond to Vanepps?
Yeah, I could ask. It'll probably be better if you asked.
Okay. I'm going to ask him. I'm going to say, listen, my honor,
and we rebuttal what Bruen Vanepps said.
Yeah, will Jamal Bay or any of us be able to rebuttal what Grant?
Wait, so hold on. What's the date we're agreeing on?
A date in December.
Yeah,
Date in December?
Yeah. And they the only reason why they said they didn't want it, well, the judge said he didn't want to do it in December, is because it would be hard to impanel a jury. That's not my fault. I'm not the one charging myself. And then since this motion is being heard as if it's new, we have a right to appeal it. So either way, this date could be potentially pushed back either way. It's just, remember the chief administrative judge, remember he said last time they want this case tried now. So again, there's a conspiracy against us. The chief administrative judge of the Woburn Superior Court, and this is what Judge Deakins said last hearing, that he's making sure that he has this case before the next circuit. Which even he said, having the date in September will be the last possible chance for him to hear this case. They want him to hear it. They want him specifically to hear it. You get what I'm saying?
I wonder why.
All right, so what are we doing?
December.
Right,
For the aforementioned reasons.
Yeah, and without turning over our rights.
Well, without being coerced to waive our rights. Because that's what he was trying to do. The only way I'll move the date to December is if everyone waives their rights. That's coercion. Not because of scheduling issues, which is what the main conversation has been about before we were even sent to the breakout room, which was scheduling issues. Not because of that, but because we want you to waive your right.
Which improves his malicious intent right there on the record for the record.
All right, so I'm gonna bring up the scheduling issues. How it just makes sense to have the date for December, and we shouldn't be forced to waive our rights because of scheduling issues. It only makes it complicated for everyone else, because even the judge said he would have to use his power as a judge to help move cases around. And then, what's her name? I can't remember her name. She said, one of her clients would object to a continuance. So we have to waive our right, so that way he doesn't have to waive his? That don't sound fair to me. All right, I'm ready to leave the breakout room whenever y'all are.
Three.
Yep.
1, 2, 3.
So, but could we do that, say, roughly 10 days out or 2 weeks out from the trial? That'd be fine, Your Honor.
Contemplated the week of the 10th or the 14th, isn't that right?
I think for us, we may want to go into the following week, early the following week, because we're at least theoretically scheduled. Is that trial going to start on the 10th or the 12th, Mr. Nacken?
13th.
Oh, right, 13th. Oh, so we could do it that week of the 10th. Actually, that wouldn't be a bad idea at all. But the
Firm, I may have overspoken with respect to our mutual availability. I thought we had it.
Mr. Nagangas?
10th and 11th, you'll be good grand jury. So really it would be Wednesday.
On panel and grand jury. So we'll do the 12th. Okay. I wondered about the email when you said that in the email. I was like, always the last to know.
But would it be available for the court the 19th and 20th?
Click that link I just put in the chat. It goes over a lot of the case law that I was arguing today. That is not my personal opinion. This is just case law. And then here's more information regarding the Second Amendment. More case law. None of it's my opinion. Case law that shows that the right to self-preservation is a natural human right, which the judge said it's not, but other judges said it is. And then this final link was my motion for reconsideration, which Judge Deakin decided to hear it as a new motion. So that's what I'm sending right now. Feel free to read all of those things. And you'll see none of this is my personal opinion. And when you read Heller, which I have referenced on the Second Amendment page, when you read Bruen, and when you read Young versus Wyatt, you'll see where surety laws were talked about, and like Rawls said, or whatever his name is said, complete prohibitions were unconstitutional either way. But he's trying to say that those complete prohibitions against people that wanted to wage war against the United States are similar to the Massachusetts statutes right now, which they also applied it to black slaves because the slaves wanted to fight for their freedom, which is waging war against the United States. So they're essentially saying that they're continuing to enforce these licensing statutes because they're afraid that so-called blacks are going to wage war against them. When I don't advocate for that. I never said that. So to say that those laws are analogous to these licensing statutes is, again, unconstitutional. Or they're trying to label me as something. Which, if you watch any of my videos, I never asked anyone or commanded anyone or told anyone or showed any interest in overthrowing any government or anything like that.
Recalling co-defendant matter.
Okay. Is everybody back from the breakout room, all three pro se defendants?
Looks like one of them is connecting to audio.
Is that Mr.
Lucha L.
Mr. L. Porter Libertad? All right.
I think he's there, but the camera's not turned on.
Or... Mr. L. Porter Libertad, can you hear us? Not sure he can.
He's retrying his audio. He might be connecting now. Do you want to ask again?
Mr. L. Porter Libertad, can you hear us?
Yes.
Okay, we can't see you, but we can hear you. Can you see us?
Yes, I can see you guys. I don't know what happened. Is after the breakout room, this happened.
Okay, well, as long as you can hear, as long as you can hear us. My only concern is that I rely on the camera so that if somebody loses their audio, they can sometimes wave to us and let us know there's a problem. But you wouldn't be able to do that if let's see, that's Mr. El Karag. Oh, there you are. Okay, we can see you now, sir. All right. I gather the defendants have been able to speak to one another, but maybe have not had a chance to consult with standby counsel. So let me ask the pro se defendants, does any of you wish to speak with standby counsel before you report back to the court?
I don't.
Mr. Abdullah Bey, I couldn't hear you. I think you responded, but I couldn't hear what you said.
I just said I don't. I don't need to.
Okay, Mr. El Karak, Mr. El Por Libertad, does either of you wish to speak to standby counsel before you address the court again?
No.
Mr. El Por Libertad?
No, my honor, I don't.
Okay. Where do things stand after the breakout room with respect to the defendant's views on scheduling the trial, or I should say rescheduling the trial?
We spoke about how it seems that to do a date before December would require a massive amount of cases to be moved around. I believe Ms. Cohen specified that she has a case where her defendant would not like to waive their right and they would object to a continuance. So it seems fitting that because of scheduling to have this hearing in December without having us to be coerced to waive our right to speedy trial simply because of scheduling. Because if we waive our right to speedy trial, then it's as if we're requesting this on our own accord, not because of scheduling issues. It just seems to make sense for everybody, so that way they don't have to move cases around and complicate the proceedings in other courts to make this happen. It just seems reasonable to have it in December.
Okay, I appreciate that view. Before I say anything, did either of the other two pro se defendants wish to be heard in addition to that?
Yes, I second that, mainly in adding to what he was saying. And so before this court hearing, I was actually placed on restrictions from talking to my co-defendants. So having a case in December would allow me more time to provide a better defense with my co-defendants, who I'm now able to talk to, due to some of the restrictions being lifted off.
And I can't see a screen right now. So who is that just spoke? Just so I understand.
Aban El Karak.
Thank you, Mr. El Karak. So, Mr. El Por Libertad, do you want to add anything to what your fellow defendants have said?
I agree with them. I join what they're saying.
Okay. So, here's the thing, gentlemen. It's difficult for me to imagine impaling a jury, getting this trial underway and finished between Thanksgiving and Christmas. And that's because those two holidays, we lose a lot of jurors, people who just can't serve on juries because of family or travel plans. Rather than December, I think the most prudent way to schedule this trial would be to start it just after the first of the year, where it would have priority. But Mr. Vanepps is shaking his head, so maybe that doesn't make a lot of sense from the Commonwealth's point of view. Mr. Vanepps, why are you shaking your head?
Because I have a 2019 two-defendant murder case starting jury selection on January 16th. And
okay,
okay.
So let me start with a different from a different angle then. I got to look at my calendar. Thanksgiving, it looks like, is November 24th. If we were to impanel, Mr. Abdullah Bey, when did you say your due date for your son is, or your child?
Around November 10th.
Okay. If we were to impanel this case, to begin with impanelment on November 27th, which is the Monday after Thanksgiving, does that pose any irremediable hurdles for anybody?
Your Honor, I have a trial scheduled. Frankly, I think it's going to be no cross before that, but I make no guarantees. I'm just trying to be as open as honest with the court as I can.
What sort of trial is it?
Rape case.
Okay. How long is it expected to last?
The problem is it's in. The problem is in other jurisdictions, they don't do pick and go like Massachusetts does. So it would be any time in between that and the entire week. So I'd have to block off the week for that.
All right. What I propose to the parties is this. I propose that we mark it down for the 27th of November for trial, which accommodates, as I see it, both the defendant's thoughts about scheduling and the Commonwealth schedule, leaving us only with the problem that Mr. Dolan may or may not have a conflict for that day. What I propose is that we set it down for the 27th, and as we approach the 27th, Mr. Dolan, if you find that the case is not going to be null pros and is not going to be continued and is actually going to go on the 27th, that you let us know as soon as you know that.
Yes, Your Honor.
And conceivably, we might then have to reschedule. But this looks like an overall, especially even given what Mr. Dolan just said, a fairly promising date. And I think if we started impanelment on the 27th, we could be assured of finishing the trial well before Christmas, meaning that we wouldn't have trouble getting jurors due to Thanksgiving or Christmas.
Your Honor.
Yes.
I don't want to talk over you and interrupt, so Your Honor's ready to hear from me.
I'm ready to hear from you. I don't want to say a lot of things and find out that the date doesn't work.
So I have what is probably the oldest non-homicide case in the courthouse scheduled for December 11th. It's the case that Judge Pierce has, let's just understate it and say that he really wants this case to go. It's a 2014 two-defendant case scheduled for December 11th. It's been continued, I can't even tell you how many times by the defense. Most of the time over the Commonwealth's objection. If we're paneling 2 Mondays before that, I just.
Okay. Let me ask it this way then, Mr. Vanepps. If we have to look into February or beyond,
that's frankly where I'm at.
You indicated you have a murder case starting in January.
Yes, I do.
What's the earliest in February that you could pivot from your murder case and impanel this case?
The 26th.
26th of February?
Yes.
Okay. Then let me turn to the defendants and ask, as you can see, we have less trial space than we have trials. As I mentioned, a continuance till December would be, or past December, I guess I was talking about, would be unusual. On the other hand, if the defendants feel that that's satisfactory, I'm willing to do it. My thought is I want to give this case a date that we don't have to change again. So I'll hear from defense counsel. Mr. Vanepps is proposing February 26th.
Your Honor, I can do February 26th.
As long as it's okay with Mr. Ferrara, I can do the 26th.
Yeah, 26th is fine with me. This is about no problem. As long as I'm not limited my rights, that's fine with me.
Well, just to be clear, if you're agreeing to the 26th date, if a continuance by agreement that's cited by agreement, you are in effect waiving your right to a speedy trial between August and February, because I can't continue a case and also, in other words, can't have that both ways.
I understand, but I don't see how the defense should be penalized for that. If it's a scheduling.
No, I agree. I agree. You're right. That's true. But as a practical matter, well, let me ask you this. I'll put it this way, Mr. Elkrock. Do you object to February 26th trial date?
I don't object. I just object to waiving my speedy rights.
Well, but if you don't object, you're in effect waiving your speedy trial rights. You can't do both. I mean, if you're telling me I object, I want a trial sooner.
Case that we've had to deal with.
Your Honor, could I make one suggestion?
Yes.
Haven't even had the right
To the extent that
our game plan to this malicious prosecution.
Lucha, you're not muted.
what I'm thinking is, to the extent it's difficult to schedule because of so many co-defendants and attorneys, if the court makes a finding.
I can make a finding. I'm just trying to. I want to know whether I'm making a finding over objection or not. That's all. Ms. Reisler-Cohn, you're absolutely right.
Separate everybody to maliciously.
And I believe Mr. O'Farrar is objecting, but again, as Attorney Reisler-Cohn mentions, that the court can make a finding. But I think in terms of what his wishes are, that is clear.
Mr. Alpor Libertad. Mr. Alpor Libertad.
Happening right now. It's not fair. I also agree with my peer. I will not be turning in my rights to make scheduling easier for anyone. We're the ones who.
All right. I understand. I understand that the defendants are not waiving their rights under Rule 36. I understand. Putting that issue aside for a moment.
I can't.
Without.
I can't hear you.
All right. I think maybe I should go back into my chambers and log on to the Zoom. So everybody, bear with me. I'm going to go into the chambers. This is a hard way to do Zoom. I thought I could save some time by staying out here, but I'm just going to move back into my chambers. So bear with me, everybody. Let me give this.
Lucia, can you hear me right now? Can you hear anything?
All right. Can you everybody hear me?
Yes, Your Honor.
Sorry, I've come back in. Well,
Your Honor, Lucha El Por Libertad was having sound issues, and it looks like he just logged off and is hopefully trying to get back in. I'm not sure if Clerk Negan Guest sees him.
we'll wait for him. Also, while we're waiting, Mr. Dolan is requesting that he be unmuted.
Thank you.
All right. So I guess what I was asking is understanding, and I do understand that at least Mr. El Parad and Mr. El Por Libertad do not wish to waive any rights, which I understand and respect. Mr. Abdullah Bey may or may not be in the same position. Either way, of course, I respect their choices. Putting aside that they don't want to waive their rights under the speedy trial, and their rights to a speedy trial, is the 26th a date? Does that pose any particular problem as a date to start the trial for any of the three pro se defendants?
Are you talking about November?
Sorry.
No, we can't. November, Mr. Vanepps can't do it November. The first date in effect that he's available is the 26th of February. But what I'm trying to do is find a date that we can carve out for this trial and be sure that it will actually go on that date.
Again, no objections to February 26th. Just again, like I said, as long as I'm not waiving any rights.
I understand, Mr. Por Libertad. Sorry, Mr. El Karak. I'm sorry. I don't see your whole name, so I apologize.
Sounds good.
I object to that.
I'm sorry, Mr. Abdullah Bey.
I apologize. I object to that, and November 27th works for me. But of course, if you make a finding or if you make a decision for anything else, just please know I objected.
I do note your objection. I'm assuming, well, now I know all three of you have objected to it. But understanding that you're objecting, there's two bases of objection. One is that you don't want to wait longer than November 27th for your trial. Second basis of objection is that the February 26th poses a hardship for you. I understand that you're objecting on the first grounds that you don't want to wait till February 26th. But are you also, is there a problem for you with February 26th as a trial date, putting aside the fact that you're objecting to the delay?
At the moment, I don't necessarily have anything scheduled, but it's all confusing to me because when I suggested December at first, I had to waive my right and it was impossible. But now we're going past.
You don't have to waive your rights at all, sir.
I understand that. I'm just noting for the record that when I had suggested December, you specified that you would do that only if we all waived our rights under Rule 36, because it's unusual. Right. Then I suggested that we choose December because it works for everyone. But now Mr. Vanepps is suggesting February, but now that's not being called unusual, and no one's being penalized for that.
It is.
So I'm just objecting to February, period.
It is unusual. And my initial feeling was, if all three of you were happy with a date in November or December, I would be happy to postpone the trial to that time if you all waived your rights under Rule 36. It was then brought to my attention that you do not waive your rights under Rule 36, which is fine, and therefore I have to make a decision over your objection. It would have been easier for me to make the decision if you were all in agreement with it. You're not all in agreement with it, as is your right, and that's fine. The decision becomes harder for me, but I still have to make it. One data point that I need to have in order to make it is whether the 26th of February poses a problem for you.
Well, of course it does. I mean, this entire fiasco has been very burdensome on myself and my loved ones. You know, there's members of the community that ask about it because, you know, I was essentially called a terrorist in the news, and people still think I'm in jail because of the awful things that were said about me. So, of course, this is burdensome, and I would like to accomplish this in November if I can. But I understand all of these decisions, not one decision has been made in my favor. So whatever happens, happens. I believe I'll be ready in November so long as my standby counsel gives me the transcripts from the other motion to suppress hearings where Trooper Ryan Casey clearly lied, and the record will show that. Other than that, I mean, I'm putting my faith in my God, and I believe that November 27th is the right date to choose.
But I'm not going to choose that date because I understand from Mr. Vanepps that he has an older case with, I can't remember if he said people in custody, but it's at least an older case, not in custody, but a significantly older case that he has been held for trial by the Regional Administrative Justice. So I can't contravene that. So what I'm going to do is this. I'm going to schedule the trial date for February 26th. I note the objection of all three defendants based on speedy trial grounds. I intend to make a finding that the interests of justice, which comprehend not just this case, but all the other cases that have to be scheduled, requires the continuance. I am going to submit this trial date to the Regional Administrative Justice for his approval because we're going out of protocol. Normally what would happen is the case would go back to the first session for trial schedule. But where there are 3 pro se defendants, 3 standby counsel, and 2 ADAs trying to pick a trial date, it seems to me to be right to pick the trial date now so that we don't run the risk of losing that trial date as we proceed forward. But I'm going to set the trial date subject to the approval of the Regional Administrative Justice. If the Regional Administrative Justice doesn't approve, I will then refer the case back to the first session for schedule. I'm optimistic that the Regional Administrative Justice will approve the date. I think that's very likely. But I want to be clear to everybody that if the Regional Administrative Justice feels that I've overstepped my authority in setting this trial date, we will then reconvene and I'll refer the matter back to first session. So I'm leaving up to him the final call as to whether it's appropriate to step out of protocol and set the trial date this way in this case. I will try to have a decision for you on the motion to reconsider as soon as possible. Is there anything else that we need to address today?
No, Your Honor, thank you.
I did have a question about last hearing. We talked about the sovereign citizen motion and the other motion I filed. Did you make a decision on whether or not you wanted to hear those?
I have not, Mr. Abdullah-Bey, to be candid with you. I was focused on this motion and lost track of them. Can you tell me, let me pull them out so I don't do that again. You don't happen to know what paper numbers those are, do you?
I don't.
You know when they were filed?
No, because I mailed them. I didn't go in. So
Roughly when did you mail them?
Oh man. I can check the date. Hold on. I just have to find the original.
Your Honor, it's number 82.
82? Is it just one motion?
There were two. One was requesting to bar the courts, the Commonwealth, the prosecutor, and everyone else from identifying me as a sovereign citizen. And then the other one was asking to give full faith and credit to specific documents that may affect my status in this court, challenging,
That's
of course,
83.
jurisdiction.
Okay. The motion to bar anyone from referring to you as a sovereign citizen is more in the nature, as I understand it, of a motion to eliminate for trial. In other words, I don't usually bar anybody from referring to anybody a certain way in the pretrial phase because I can sort out claims that are substantive and claims that are not. So I wouldn't typically hear that before the trial. That's a more of a trial motion. Moreover, I haven't heard either Mr. Vanepps or Mr. Rawl, either in their argument or in their papers, refer to any of the three of you as sovereign citizens.
So there is specific evidence that the Commonwealth plans to enter. Well, I'm not sure how I should phrase that. There are particular articles that the Commonwealth plans on entering as evidence where I am referred to as a sovereign citizen. And right. Throughout the entire preliminary hearings.
That's a motion to eliminate for the trial judge. In other words, I generally don't decide trial motions until I know that I'm the trial judge. But I don't see any reason to do it here.
And the fact that it's been used against me this entire preliminary process doesn't mean anything?
It's not clear to me that it has been used against you, or maybe
it has. And if I may, just
it hasn't affected any decision that I've made, either directly or indirectly. I don't think that the term sovereign citizen has any legal meaning. It certainly has no legal meaning to me.
Yes, but it has been used against me.
It couldn't be used against you in my courtroom any more than if somebody called you a jabberwock.
I understand that, but my question pertains to the entire preliminary process where Mr. Vanepps has used the claim that we don't believe in the laws, or we believe that the laws don't apply to us, or he has said out of his own mouth that we're sovereign citizens during dangerousness hearings, during several hearings where he's used this term, but you're saying has no legal meaning, but it has still been used against us. So how is it that this term has no legal meaning, but it implies domestic terrorism and so-called paper terrorism, but there has been no evidentiary hearing to prove that I am that. It's confusing to me, and to me, it appears that my entire preliminary right to due process has been violated because I've been labeled something without any evidence to prove that I'm that thing, and decisions have been made when regarding things that negatively affect me, negatively affect my defense, negatively affect my status as being innocent until proven guilty, and he's just been allowed to just say it. But now, and you're the only judge that has been honest with me about this, now you're telling me it has no legal standing, but even the police are briefed on what sovereign citizens are, because Trooper Casey said out of his own mouth within the first 13 minutes of the incident, telling another officer that arrived on the scene that we're sovereign citizens. So it doesn't make sense how the court is saying that it doesn't have a legal status, but police officers are being trained on this thing regarding sovereign citizens as if it's a legal status of people that don't believe in the law. It's very confusing to me.
I can't speak for what police officers say. Police officers, like everybody else, get things right sometimes and wrong sometimes. What I can tell you is this. The term sovereign citizen has no meaning to me. I haven't seen any decision of any other judge in this case that has invoked or otherwise rested anything on a claim of sovereign citizenship. And I believe pretty strongly that's because it doesn't have any meaning. It's a term that's used popularly in the sort of the popular parlance, but it has no legal meaning. I certainly haven't held it against anyone that they've been called a sovereign citizen, because it has no legal significance. What I'll do with these motions, I'll look and see whether I'm going to need to have a hearing on them. With respect to the sovereign citizen motion, I'm pretty sure I'm going to defer that for the trial judge, because the trial judge may want to make a ruling on that motion to preclude references in front of the jury. We really worry in these type of motions about juries, because they're the ones who have to make the findings of fact.
And if the jury pool has been infected because the media has used this, and as well as my peer just said, the prosecutor has used this, and judges have denied, judges before you, which you've seen maybe like 10 judges before you, have denied motions that we have put in on the using the excuse that we are sovereign citizens.
Yeah, I haven't seen that. I haven't seen any evidence of that. In any event, the motions, I will let you know if I think a hearing is required. It looks to me as if the hearing on the motion that pertains to the full faith and credit clause recapitulates issues that have been presented and decided, but I can't know that until I dig into it.
That has been decided for other defendants where I wasn't joined in those motions. I wasn't even aware that those things were filed, and I'm pretty sure they didn't make the arguments that I've made. But
all right, I'm not. What I can tell you is I'm not going to have a hearing on it now, because I haven't prepared for a hearing on it now, and I don't want to make decisions off the cuff. I'll review it and determine if I need a hearing or not. If I need a hearing, we'll schedule one.
okay, thank you.
All right. So we'll have a trial date scheduled for the 26th. It is subject to the final approval of the Regional Administrative Justice on procedural grounds. If there's any change in that, we'll send you a notice. If there has to be a further scheduling hearing, either here or in the first session, we'll send you a notice. But without such a notice, everyone prepare for trial on February 26th.
Thank
Your
you.
Honor, should we be selecting a trial readiness date, or are we holding off on that?
Yeah, no, I think we should select a trial readiness date in January. Mr. Vanepps, when is your trial in January?
I'm looking at my calendar. It begins, jury panel is the 16th. So maybe sometime the week of the 30th, perhaps, for a trial readiness?
I think that's fine. Does anybody have a strong preference for a day on the 30th?
So I'm sorry, so trial readiness on
Sometime in the week of the 30th. I'm just looking for Are those typically held, Mr. Nagan? Are those typically held at 9 or at 2?
Is it staying in first? Is it staying in our session?
Yes. I mean, subject to the approval of the Raj, it's staying in the session.
And it should be at 2.
Yeah, no problem.
at this point I'm free the entire week.
Other counsel have any preference the week of the 30th of January?
I'm available, Your Honor.
Anytime, Your Honor, is fine.
Are the typically defendants appear in person for trial readiness conferences? Do the defendants prefer to appear in person or via Zoom?
Zoom works for me.
Mr. Elkarock, Mr. El Porter-Bertad? Can't hear you. Oh, Mr. Elkarock is muted again. I don't know why this keeps happening.
That works for me.
You prefer Zoom?
Yeah.
Mr. El Porter-Bertad?
Yes, I prefer Zoom, Your Honor.
Okay. The defendants may attend the trial readiness conference via Zoom. In fact, perhaps we'll simply have the trial readiness conference via Zoom. And what date? It doesn't appear that anybody has a strong preference. Mr. Vanepps, I'll let you choose if no one else is speaking up.
Sure. Why don't we do February 1st? It's a Thursday, 2 p.m.
February 1st work for everyone?
Yes, Your Honor. Yes, sir.
All right. So I'll issue a scheduling order today or tomorrow, setting all this out in writing, including that it is subject to the final approval by the Regional Administrative Justice. And if I want to schedule a hearing on either of the two of Mr. Abdullah Bey's outstanding motions, parties will receive notice and we'll schedule a hearing.
Thank you, Judge.
All right. Thank you, everyone.
Thank you.
Good afternoon.
Thank you, Your Honor. Thank you, Mr. Clerk.
Oh. Yeah, so was Vanepps. I'm still live, just so you know.
So then they went back and put you guys in a different group, and they kept me in the court group.
Yeah.
And it was all time. And someone sent a comment in there because they must have put somebody else who's on YouTube in there as well.
Yeah.
Someone commented. Did you put it public?
What?
The link to the Zoom.
Yeah, I did.
That's how they know, because I'm like, someone commented saying they even talked about how long it would take for them to get. I'm not clear because it's a lot of.
Yeah.
Going on.
Yeah.
So I'm not clear if it was the appeals court or if they were talking about the jury, how long it would take them in total to wrap everything up, basically get a conviction, and then the stupid little young protege is like, oh, we can have it done in under an hour.
Yeah.
And they were all laughing.
Yeah.
and
if that's not a conspiracy, I don't know what it is.
Then they tried doing it in July because Vanepps is like, yeah, let's move it sooner, maliciously, and then the judge was like, okay, but. How
realistic
are you going to be for this realistically? So then they changed the tune. Because they were talking about that he wants to do it so that way, because he was literally saying he's considering how easy it would turn over in appeals and shit.
Exactly, because of the Fourth Amendment right to due process.
Yep, so
Trooper Ryan Casey said out of his own mouth he's seen guns and he investigated us.
They're trying to plan it so that you don't get it overturned easy and shit like that. That's what they were talking
about. I know,
I
know.
You heard that?
Well, no, I know that's their plan. I know that.
Yeah.
Because everybody knows all of the attorneys from the beginning. Remember, I was the only one that didn't have an attorney. From the beginning, they were telling them you have a huge Fourth Amendment argument. Every single, since I'm not a licensed attorney and all the people online say, well, they don't know what they're talking about. All of these licensed attorneys who do this for a living said we have a huge Fourth Amendment violation that has been clearly articulated before Justice James Boudreau, who called me a sovereign citizen and based his decision on denying everything I said because I'm a sovereign citizen and misinterpreting the law. But now Judge Deakin is saying that has no legal standing. So how can it be used against me?
Documented on Vice that these agencies are fucking being briefed on.
And that's how Ryan Casey was able to say that, because they get briefed on these things.
So now because they realize realize since they're not going to be realistically ready in July and and that it could be overturned easily. Now the tune has changed. Oh, we can do it in December, and you don't have to waive your rights.
Yeah, but at first we had to waive our rights.
Yeah, because they didn't realize the whole.
These people are sick, man.
Yep.
They're absolutely sick.
And I was like, yo, these people really don't know that I'm here, and I'm just sitting here like.
Good.
I wish that I was recording. But
These people are demons.
They were gonna be doing that, but
Yeah.
since they don't really know who the fuck is who, because
they don't.
Because when they sent you to the breakout rooms, they sent me and Rashad to a separate one to keep us out of the court thing.
Yeah.
So then I clicked leave, and I ended up back in court, and I was just listening.
Yeah, they had Vanepps with us. I was like, what is this?
I saw.
Yeah, these people are criminals, man. And it's like, he has no intention on granting this motion at all.
Also, sidebar, you ate them the fuck up. At first,
Thank
I was
you.
a little nervous because you were sounding rusty.
It's because this is the truth. I get cold.
I know.
I literally get cold. I don't know what's going on. I get cold. It's like, because I was gonna read this whole thing. I mean, it's only 6 pages. It looks like a lot. I was gonna read this whole thing, but then he was like, try to keep it brief, and I was like, okay, well, I'm not trying to be here for 3 hours.
Yeah.
But this is the historical analysis. Like even in Vanepps' their response, they did not mention not one
He sure
law.
mentioned surety.
Yeah, but
I'm like,
the surety bonds was already addressed in the Young versus Hawaii
But I
case,
mean,
and they struck that shit down.
Anytime you talk about fucking surety, it's still slave laws.
And the surety laws weren't licensing. It was not licensing. A background check is not licensing. Prohibiting the mentally ill from having, who want to harm themselves or others from having arms is not licensing. That's saying because of this, you can't do this. As opposed to just saying, I want a license, and they say no. Based off what? You know what I'm saying? It doesn't, because here in Rhode Island, you don't need a license. All you gotta do is pass a background check, and you can get an arm. You don't need a license. That's common sense.
And in the background check, are you crazy? Are you
Exactly,
murderer?
and you have to be like judicially declared mentally incompetent or something like that. You know what I'm saying? It's not just, oh, you're crazy. No, you know what I'm saying? And like, they're ridiculous. Everything that they tried to make seem like it was similar to a licensing scheme, it was not anywhere related to it. Saying that people that were pro-British after the War of Independence, obviously these British subjects can't bear arms. They're British subjects. Their allegiance is to Britain. You just got out of war with them. That's a clear set of people. Has nothing to do with licensing. Has nothing to do with the licensing of the general public. Those are complete, like the prosecutor said, those are complete bans. Which the Supreme Court said you can't do that. So nothing that they said shows any type of historically analogous laws to these laws that they're applying to us today. This is from handgunlaw.us. Yeah, I told you. Handgunlaw.us. And it shows 28 states that have constitutional carry laws. In Rhode Island, I'm not sure what the laws are now, but Rhode Island changed their laws after I got arrested. Because in Rhode Island, I'm not sure if you still, I don't know if you need a license now. But after I passed my state and federal background check, there was no law on the books saying that I needed a license to keep and bear my arms. There was no law that existed. So I passed the background check, which falls within the common sense, long-standing regulations. Passed the background check, and then I didn't need a license. But they're conflating the two. They're conflating background checks with licensing. It's not the same. They're conflating surety bonds with licensing. Not the same. They're conflating a prohibition against people that wanted to wage war with the United States to licensing. Not the same. It's not the same. And there's no historical evidence of it being the same. And you know, they kept bringing up, I mentioned this when we was in the breakout room, they kept bringing up public safety. When you read the definition of a license tax, that's exactly what it says. And I'm gonna read some of the things I read before. Oops, wrong mouse. I've said this before on another live, but in the motion to reconsideration, I addressed this. And this is some of the things that it says. This is also posted on riseofthemoors.org. This is what this Judge Deakin just was hearing. He's seen this motion to reconsideration. He decided to hear this as a new motion, but this is what he read. Justice, and this is regarding Justice Hagan's decision. His 2-page denial of my 60-page motion was not based on the standards established in Bruen. In fact, the prosecutor's opposition to the challenge statute, they provide no historical analysis justifying the statute. Instead, they relied on prior rulings using the two-prong test declared invalid in Bruen. By definition, a license falls within the prohibition stated in the Murdoch court, as one literally has to pay a license fee to then have the permission to exercise what the federal constitution already grants. This license fee thus makes the right a privilege and thus transferable, making it an infringement on rights that are, according to the unanimous Declaration on the Rights of Independence, inalienable. Henry Campbell, Black's Law Dictionary, 4th edition, page 1067, defines a license as permission to do something which, without the license, will not be allowable. Yet, the right to bear arms is a public and individual right, and the Second Amendment itself allows possession thereof. It continues to define it as a permission to do some act which, without such authorization, would be illegal or would be a trespass or tort, a permit or privilege to do what otherwise would be unlawful. And this is why I suggested that it would make sense that a felon would need a license. Let's say you committed mass murder, you got out of jail, you served your time, if you're not there till natural life, and you get out and now you're afraid that people might harm you. Yeah, you should probably pass some test and get permission to do that since you have a history of killing people. So it makes sense that you have strict scrutiny for people that are in specific boxes, right? But not the general public, which is exactly what the prosecution was alleging when he said that people that were pro-Britain couldn't bear arms. That's not the general public. Those are specific people, right? Yet the Second Amendment already allows, permits, and make lawful the possession of arms. There are several states with constitutional carry or permitless carry laws. Those laws are entirely based on the fact that the Second Amendment already guarantees the right to keep, possess, carry, and bear arms without a license. Therefore, no one needs permission, which a license is permission to exercise said right. In Chief of Police of Shelburne versus Moyer, the Massachusetts Court of Appeals concluded, consistent with Davis, that a statute requiring a person to have a license in order to carry a firearm did not violate the Constitution because there is no right for a private citizen to keep and bear arms, and thus to require that a citizen have a license to do so is not constitutional. Clearly, with the Heller Court's decision, according to Massachusetts Courts of Appeals, since there is an individual right to keep and bear arms, any law requiring a citizen to have a license is in fact unconstitutional. That's their own reasoning. Black's Law Dictionary also states that a license is a privilege from the state or sovereign. The Second Amendment specifies that it is a right. The Supreme Court has already confirmed that the Second Amendment codifies a pre-existing natural right. Rights are clearly distinguished from privileges. So with the nature, purpose, and plain text definition of a license, it is unconstitutional to license a right. According to page 1487 of Black's Law Dictionary, under the subsection constitutional law, a natural right is defined as, quote, those which grow out of the nature of man and dependent upon personality, as distinguished from such as are created by law. They are those which are plainly assured by natural law, in order to fulfill the ends to which his nature calls him, unquote. Clearly, things that are derived from nature cannot be licensed and are not privileges from the state or sovereign. The book continues to state that the term right in civil society is defined to mean that which a man is entitled to have, or entitled to do, or entitled to receive from others. So how could you possibly be entitled to something, entitled to do something, and entitled to receive something, but then you need permission? Doesn't make sense. It's called a logical fallacy. A privilege, by contrast, is defined on page 1359 as, quote, a peculiar advantage, exemption, or immunity enjoyed by a person, company, or class beyond the common advantages of other citizens, which is exactly what the licensing scheme was designed to do for Negro slaves.
I just wanted to remind you, we have that next meeting.
Oh, yeah. An hour, yeah. Anyway, this is all available on riseofthemoors.org. What I didn't get to read, which I posted it on the Rise of the Moors Instagram, was more historical quotes showing state laws prohibiting blacks from bearing arms without a license. And I read it briefly for the court, and he stopped me. I wonder why. But I read the Virginia law. As the Virginia court held, among the numerous restrictions imposed on this class of people, free blacks, in our statute book, many of which are inconsistent with the letter and spirit of the Constitution, both of this state and the United States, was the restriction upon the right to bear arms. This was given in the amicus curiae brief to the Bruen court, which they gave a whole historical analysis in favor of. I think the guy was Bruen, right? In favor of the people challenging the New York statute, and this was given. Anyway, However, Virginia's only restriction on free citizens was not enacted until 1838 and related just to the manner of bearing arms. If a free person habitually carry about his person, hid from the common observation, a pistol, he shall be fined. So it wasn't a license. It wasn't a license. It was a regulation on the concealed carry of firearms, which I'm not being charged with. I'm being charged with the open possession of arms in public, which is not the same thing. Other southern states recognize the right to carry arms by free citizens subject to restrictions on concealed carry and either banned carry by African Americans or subjected it to discretionary licensing. The Kentucky Constitution provided, quote, that the right of citizens to bear arms in defense of themselves and state shall not be questioned. Its restrictions on concealed carry was declared violative of that right. Bliss versus Commonwealth. However, Kentucky law provided that no Negro, mulatto, or Indian whatsoever shall keep or carry a gun except that every free Negro, mulatto, or Indian, being a housekeeper, may be permitted to keep one gun. And all Negroes, mulattoes, and Indians, bond or free, living in any frontier plantation may be permitted to keep and use guns by licensing from a justice of the peace. So again, this is posted on my Instagram. I'm not going to read the whole thing. Just case law after 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 case law, pursuant to the standards established in Bruen, show only that the only time a license was ever used on any person were nigger slaves. I am not a nigger slave. I'm not black. I'm not Negro. I'm not colored. I'm not African American. I'm not Indian. I'm a Moorish American. Period. Anyway, thank y'all for tuning in. Hope you learned something. Hope you learned how corrupt these demons are. And before I conclude, let me state for the record that these people were arguing that the Second Amendment was not an individual right, and thousands, if not hundreds of thousands of people were sent to prison because of that illogical reasoning. It states in the Constitution that it is a right of the people. The people is plural, but guess what the people consist of? Individuals, which means what? Every individual has the right. So of course it's an individual right, but judges and prosecutors were arguing that it's not. Hundreds of thousands of people were injured because of that. Hundreds of thousands of families were destroyed because of that. People who had no intentions of harming anybody, just protecting themselves in case of confrontation, which I provided copious amounts of case law that show that in this live chat and on my website of judges' decisions stating these things. These people with no malicious intent, no ill will towards others, no desire to harm anyone, were sent to prison. Children not being able to see their fathers and mothers, mothers and fathers not being able to see their sons and daughters because they were convicted of exercising, but instead it's under the guise of color blindness. Hold on, let me read this. Let me see if I can find it. Maryland made it unlawful for any free Negro or mulatto to go at large with any guns or other offensive weapons. However, this did not prevent any free Negro or mulatto from carrying a gun if he had a certificate from a justice of peace, and that he is an orderly and peaceable person. And the Court of Appeals of Maryland described free Negroes as being treated as a vicious or dangerous population as exemplified by laws to prevent their migration to the state, to make it unlawful for them to bear arms, to guard even their religious assemblages with particular watchfulness. Let me find this particular thing. Alabama provided that no slave shall keep or carry any gun, but added that any justice of the peace may grant permission in writing to any slave on application of his master or overseer to carry or use a gun and ammunition within the limits of said master's own plantation. This was Alabama state law. And remember, one of the prosecutors brought up the issue of hunting. That's the same exact thing in slave laws. It's the same exact thing, right? In the Bruen case. But there's a particular part that they try to apply it to free whites, and they didn't even abide by it because it was unconstitutional, and they say it. Look, this was regarding the issue of the 14th Amendment. The above judicial decisions were noted in a report from General Ulysses S. Grant, stating, the statute prohibiting the colored people from bearing arms without a license is unjust, oppressive, and unconstitutional. Congressional Globe, 39th Congress, 2nd Session, 33, 1866. Let me read it one more time. From General Ulysses S. Grant, who became the president. The statute prohibiting colored people from bearing arms without a license is unjust, oppressive, and unconstitutional. Again, this is from the amicus curiae brief in the Bruen decision of the United States Supreme Court. Perhaps. Well, my audio is fine. I'm looking at the mixer right now. It's fine. A $100 bond with approved sureties. Florida law 71, beyond the means of poor persons, not to mention the unlikelihood of them being issued to African Americans. The law was passed when there was a great influx of Negro laborers in the state, and it was for the purpose of disarming the Negro laborers. The statute was never intended to be applied to the white population. Watson versus Stone, 148, Florida, 516-524-4, 2D700. So even in the prosecutor's alleged analogous surety bonds, they were what? Based on what? Prohibiting so-called Negro slaves from bearing arms. It's the same thing. The same exact thing. Moreover, it was estimated that 80% people, because it has been generally conceded to be in the contravention of the Constitution, non-enforceable if contested. So they already knew when we enact these laws that require surety bond to bear arms, they already knew it was unconstitutional. And it didn't apply to white people. So it doesn't matter how, it doesn't matter. The history is the truth. Anyway, I've been live for 2 hours. I'm tired.